Hello, my dear friends. I'm Stanislav Shamayev, a licensed business immigration and corporate attorney in Miami, Florida. So today we're going to be talking about the concept of dual intent. And I'm going to be using the O-1 visa as an example to explain it to you because it's very important to know what that is. At the end of this video, you will be able to learn how to get a free evaluation of your case in the category of business, investment, and talent visas to the States. Let's go. And of course, guys, you know the drill. Smash that like button and subscribe to my YouTube channel so YouTube spreads this video to as many people as possible. And you know that this channel has the best content among other immigration attorneys. Okay, so dual intent, very important concept in immigration law. Why? Well, because if you know it and you use it properly, then you will be able to immigrate to the United States faster. If you don't, you may get in trouble. Let's first split the US visas in two categories with a dual intent and no dual intent. This makes sense only in non-immigrant visas because we have immigrant visas and we have non-immigrant visas. If you don't know what I'm talking about, please watch this video where I explain the difference between these two huge categories. In short, any visa that starts with EB, employment based. There are 5 categories of those visas. They're all immigrant visas, meaning that once you get approval for those visas, you basically get an approval for a green card. Nothing there about dual intent because this is an immigrant intent, right? You intend to immigrate. So this has nothing to do with this video. However, the non-immigrant visas, the B1, B2, F1, M1, J1, O1, P1, E2, L1, H1B, and other visas that don't have EB in front of them, they're all non-immigrant visas. And in non-immigrant visas, it's important to understand so which ones of them are dual intent and which ones are not. I'm not going to just give you the list of which one is which because this is just too big. But among the visas that I do, I can tell you that O1, L1, H1B, P1 are the visas that have dual intent. And the visas like B1, B2, F1, M1, E2, they don't have dual intent. Dual intent means that when you file for this category of visa that has a dual intent, you may want to immigrate to the States and you may be open about it. So let's say you're getting the O1 visa, and when you go to the embassy to get your visa stamp, you may not worry about proving to the embassy, to the US government, that you have a good job, that you have relatives, that you have family in your country, that you have property in your country, that you basically want to come back, right? You don't have to prove it, meaning that you want to come here in the States and stay here in the future and get a green card, right? So that's why L1 visa, O1 visa, and other visas with dual intent, they are much easier to get in the embassy because once you get an approval, basically the end of inquiry, right? It's just the formal process where you go to the embassy and you get your passport stamp. Of course, there could be denial because of other things like criminal record, or maybe there is some suspicion that you worked in the States before without work permit and things like that. They can put you on administrative hold. So there are circumstances that can bring you some risks, let's put it this way. But in general, it's very rare and usually it's non-existent. But if you want to get the tourist visa, if you want to get the student visa, if you want to get E2 visa, which is investor's visa, you have to prove to the consular that you will be coming back to your country. And how you prove it? Well, you have to have property, you have to have a travel history, you have to have family back at home, you have to have maybe a job or maybe some streams of income in your country. You kind of have to proactively show all those documents and papers to make the consular believe that you will be coming back. And this is very important, especially with E2 visa, which is like investor's visa, and I don't understand why it's not dual intent, because you just come to the States, you invest, you grow the business, you give the jobs to the Americans, you pay taxes. I don't know why it's not dual intent, but whatever, it's the US government thing. But you actually have to prove that you're coming back. So again, dual intent is the concept in the immigration law that provides you with opportunity not to prove that you will be coming back to your country if you're getting the visa that has dual intent. So before applying for visa, before starting preparing for this visa, make sure that you know if that visa has a dual intent or it does not. And based on that, you have to strategize how you're going to prepare your documents, how you're going to prove your case, and how you're going to prove that you're coming back or not. If you guys still have questions about that, drop them in the comment section. Otherwise, if you want to get a free evaluation of your case, if it's a business visas like L1, E2, EB5, if it's a talent visa, O-1, EB1A, EB2 national interest waiver, or business visas, L1 or E2, there are links below this video. Find the proper link, answer the questions in the questionnaire, and I'll get back to you within 48 hours. I will give you analysis of your case. And if I like your case, I will invite you to the immigration planning, where I will build a strategy how to file your particular petition. I'm Stanislav Shamayev, the lawyer of the future. Your future begins here. Good luck.